Bob, thank you so much for spending this time with me today talking about charter school law and the training that board members now have to get in order to understand that law. Could we start by talking about that training, what topics our board members need to learn, since so many of them have no background in charter schools or even in public schools?
Sure. Rosemary, you'll find a reference to the training in the Commissioner's rules that have been adopted under the school laws. I've got the school laws over here in the school law bulletin. I've got some of the rules over here in my lap, and let me help you understand what some of these training rules are. The Commissioner has required that board members, and I understand you're interested in board member training.
Yes, I am.
Will be required to have 12 hours of certain topics, modules. And those topics include a basic law requirement, which director and duties and liabilities, duties, nepotism, conflict of interest, what a management company is. And then basic school finance, accounting, public funds, student attendance, grant admissions, audit requirements, things like that. The basic school law has to run for a minimum of 150 minutes. The school finance is for 60 minutes. Beyond that, there's a requirement for a module in health and safety, which is for 30 minutes. A finance and accountability section for 110 minutes. Student accountability runs for 60 minutes, and open government, open meetings will run for 60 minutes, and the open records, which includes record retention, will run for another 60 minutes. Now, if you add all those modules up, you'll find that they don't come to a total of 12 hours, so there's some elective time in there. But the basic requirement is what I've just given you.
Well, if we're going to talk about school law generally, let's start there, because it's probably the basis for everything else. And I know you've got this not-so-small red book next to you. What would we find? What laws apply and where would we find them?
Well, you know, when we first started off charter schools, we believed that we were going to be immune from many of the laws that are...
I remember that.
Yes. Well, we found that it's not quite as accurate as we first understood. There is a chapter, a rather small chapter, in this large book, which this book, by the way, contains more than just the Texas Education Code. But there's a small chapter in the Education Code that's called Chapter 12. It's the chapter that's devoted to charter schools. Among the schools discussed are the open enrollment charter schools, which is just several pages, actually, in that chapter. But you know, charter schools, in order to become a charter school, have to be what's known as a 501c3 entity. Now, that means that the charter school has to have a certain designation and status from the Internal Revenue Service for charitable organizations, and that is 501c3 designation. Our laws require that all charters be 501c3s. In order to get to be a 501c3, most of our charters have gone through Texas nonprofit corporation status. They have become nonprofit corporations in this state or in another state. And of course, there are laws that affect both the 501c3 status on a federal basis and rules, and there are laws that affect nonprofit corporations. These apply to charters as well as what's in Chapter 12, as well as all the laws that are referenced in Chapter 12 that also apply to charter schools.
Well, are we going to find the federal laws that apply to nonprofits in this red book as well?
No.
Okay.
If you had one of these red books, you're not going to find the federal laws. You'll have to consult a whole a library of red books.
I was afraid you were going to say that, Bob.
Usually referred to as the United States Code. So you'll find various references in the code and the regulations regarding charter schools.
Well, in addition to the federal laws that you're talking about now, if it's not in Chapter 12 and I find the time, or my board finds the time to peruse this book, how are they going to know whether it applies to a charter school or not outside of Chapter 12?
Well, first of all, you may find a particular law expressly states that it's going to apply to a charter school.
That would be
That's pretty easy.
That would be nice.
Right. And then the way the laws have been described for us in Chapter 12, and and some Attorney General decisions. Our state Attorney General has interpreted some of those laws. We know that laws that refer to schools as opposed to laws that refer to school districts are going to apply to our open enrollment charter schools. So in other words, if you got some laws out there and the topic of those laws is school district, that, unless it's expressly made applicable to your charter school, is not going to apply. If there's a law out there and it refers to a school, a public school, that's going to apply to your charter school.
Well, that's a good rule of thumb for us to start with.
One more. If there is a law in the education code and it describes a criminal penalty, there's a criminal penalty attached to that law, even though it's found in the education code. In other words, it has a penal provision to it,
Okay.
like a criminal statute. That law, by Chapter 12, is made applicable to the open enrollment charter schools.
Well, at least that's referenced in Chapter 12 where we can find it.
It is.
And those are probably pretty important provisions since they're criminal to begin with. You know, my board, and I think probably most charter boards, did not have any background other than a little bit of board membership in some nonprofits outside the school industry. Tell me a little bit about how much freedom they have in establishing a governing structure. Can they just kind of evolve and change as they go? Do they have to record that somewhere? Do some of the laws you're referencing give them parameters?
Well, yes. Provided that your nonprofit corporation is set up under the requirements of the Nonprofit Corporation Act, of whatever state you're working with, Texas mostly.
And ours is.
Well, most of them are. You have the parameters that are allowed under that law. In Texas, we have a requirement for 3 officers. You're going to have a president, a vice president, and a secretary. Other states have different requirements.
But you can have more if you choose.
Certainly you could have more,
okay.
and well, everybody does. And you can also have a quorum can be described differently in your bylaws and articles of incorporation than perhaps an ordinary quorum of just a simple majority. The number of board members that you're going to require can be described and is described. And all these descriptions that are in your bylaws and articles of incorporation are included as a requirement in the application for your charter. When you apply for your charter and receive it, you're required to present these articles of incorporation.
Does that mean we can't ever change the way we're structured?
You can change them, but remember, the application for the charter has been considered by the Texas Education Agency as the charter. It's not just that little 2-page document that's the contract, but all the other materials that are presented with it. And that includes your articles of incorporation, your bylaws, the description of your curriculum, how your governing structure is going to run, how you're both in the school and for the board. And when you make changes to these things, you are then required to apply for a charter amendment and make those changes there with the Texas Education Agency too.
Well, it'd be easy not to keep up with that. I'm glad you're warning us about that right at the outset of this training. And I actually am a little unclear about the group of folks that came on my board originally. Is there any kind of provision under any of these laws that would make me worry about eligibility once we become a formal charter school and a nonprofit? Anybody who can't serve?
Oh, I get it. I understand what you're asking now. Yes. Now, when you make your original application, you're going to be presenting the Texas Education Agency with a lot of information about the various people that's on your board. They will help you decide whether or not those persons qualify as board members. But you need to know what the qualifications are, because there's a possibility that the circumstances can change after the charter has been formed, and it's a possibility that people can become disqualified to serve on your board. Persons that are convicted, it's different from arrested or charged, but convicted of a felony crime or a crime involving moral turpitude, and I know you're going to ask what that is in a minute.
I think everyone's asking that question.
Those persons cannot serve on a charter board or on it. And let me make a distinction here, Rosemary, for just a moment. I want to distinguish between the board of a charter holder and the board of a charter school. When you make your application, you usually will be describing both. And sometimes they're the same body. But at other times, your school may be actually governed by a separate set of persons, another board, sometimes even formed as a separate corporation. And the charter is held by another corporation or another board.
So you're saying we could have one board or two boards?
You could.
Okay, but two names are out there in the law.
Yes. And when we're talking about the qualifications, these qualifications are going to apply to either of those boards. So we've just talked about the criminal aspects. You can't have a criminal record, at least not one that is a misdemeanor involving moral turpitude or a felony. You may not be in a nepotistic relationship, and I know you're going to ask about that too.
I am.
You may not have a conflict of interest as described under the law. You cannot have a substantial interest, and what would that be? Well, we'll have to talk about that too. In a management company, and what would a management company be? That's another question. And all these criteria will apply to service or your ability to serve on one of these boards.
Should we start with moral turpitude? You want to enlighten me about what that is?
I wish I could enlighten you fully on moral turpitude because actually I was just looking at that this morning to respond to another client who had a very similar question. And moral turpitude, there's not a list of crimes that are, no definitive list of crimes that are crimes of moral turpitude. Basically, it means crimes in which a moral judgment is involved. And these are, in order to know that list of crimes, one would have to consult every one of the cases that have been decided in the state of Texas, determining whether a crime was moral turpitude or not.
So if it comes up, you should probably contact your attorney.
That is my advice. Rather than try to give you a definitive list, I'm going to suggest to you, you contact your lawyer. Of course, the agency will help you initially when you make your application, and they'll help you on the renewals, which I can talk to you about at a later time too. But that's my best advice.
What other types of words or definitions might trip us up out of the eligibility areas? You mentioned nepotism.
I did mention nepotism.
I know we'll probably talk about that more in depth as we go forward, but is there just a short definition that?
Well, nepotism is a familial relationship, a family relationship, which is either by blood or marriage.
Okay.
And depending on the closeness of the relationship, may be a violation of law. Now, of course, it's not a violation of law to be a brother-in-law to somebody, but it would be a violation of law to be a brother-in-law and to be serving in a nepotistic relationship, such as being a board member and being a superintendent of a charter school, for example.
Will we be able to talk a little bit more about some examples under the conflicts here? This is a type of conflict, isn't it? A nepotism relationship? It could, potential conflict, maybe.
Well, the law actually distinguishes between nepotism and conflicts of interest because these are concepts that aren't new to charter schools. These have been applied to governmental bodies, school districts included, for decades. And they have been adopted by the charter school laws and by the Texas Education Agency as they have interpreted those laws for us. So conflict of interest means that there is a business conflict of some type where one would tend to profit in a certain way as distinguished from other people by a decision of a charter school. And there's a description in the law as to what constitutes a substantial interest and when the law would be applied.
Well, you know, I think that what I'm learning is that the laws that probably governed my board members when they were on other nonprofits that weren't schools is probably only a small subset of what they're going to have to learn about here today.
Yes, it is. There are a set of laws that that deal with similar issues for nonprofit corporations. The charter laws go well beyond those.
So how do they minimize that? Can they get out of some of the liability by delegating authority to their CEO or other employees in the school?
Well, you've said the magic word, liability. And, you know, in my experience, that's the first word on the lips of board members.
Mm-hmm,
Both
certainly is.
before they come on and after they're on, and when they're sitting there pondering these decisions, dealing with large sums of money many times. They want to know, am I liable for my decisions? Let me give you the good news.
Okay.
Okay.
We'll start with that.
The good news is that officers, employees, volunteers for public school districts have almost, and I say almost, there are some exceptions, but have almost blanket immunity from tort claims, and I'll explain that in just a minute. But how does that help us? Well, it helps us because the law has stated that the charter schools have exactly the same immunities.
Well, they'll be happy to hear that.
Yeah.
What about delegation, then? Does that impact at all their liability if they have employees that they rely on to fulfill their responsibilities?
It does, because of this. Charter school boards are going to be held primarily and ultimately responsible for the actions of the charter school, decisions of the charter school. Now, when you ask about delegation, what you need to know is that the delegation of a duty to somebody else by a board of directors does not limit that liability. So even though I, as a charter school board member, might join my fellow board members in delegating to the superintendent or maybe to the school board that's running the school, the ability to make certain decisions, in the end, I'm going to be held responsible for those decisions.
So delegation can help you fulfill your accountability, but it really doesn't release you from accountability, is what I'm hearing.
Excellent. I'm glad you put it that way.
What about changing that? What if you start out and your charter has some very broad delegation and you decide that as you're learning more about, through this training maybe, about the law and about your accountability, you want to narrow that a bit. Can you make a change in that delegation balance?
Yeah, you can. You can change the delegation. Once you change the delegation, you also have to describe that change in your charter. Because when you started off, when you had your initial charter application, you described in that initial charter who was going to have the authority to make certain decisions.
See, most of us don't even remember what that said.
I know. And so when you make those changes along the way, you should go back and and cover that in your charter. You're required to do that.
Is that a formal amendment? Is that
Yes.
what we would be doing?
Yeah,
Okay.
yeah. But delegation amendments are of a couple different types in the agency, and there's some that are very, very easy to get. Just make the application and they will bless it. Before we leave delegation, Rosemary, I was looking down here at the rules, and I want to make something very clear to you about delegation, and that's according to the Texas Education Agency's Commissioner's rules, there are certain duties of a board that are non-delegable. The charter holder board, they cannot be delegated, and I think you need to know what they are.
I think that's important.
First of all, there must be, with that board, the final authority to hear and decide grievances. What kind of grievances? Employee grievances, student grievances, parents' complaints. Now, does that mean that you have to have a hearing before the board for all three of those grievances? No, it does not. The law doesn't tell you what kind of process you have to use. You could use a written presentation. But in the end, the authority and the ability to make that decision must reside in the charter holder board, And there should be a description in your policies, and perhaps in your charter application too, of that process.
Sounds like we need to review our charter.
Here's another one. The final authority to adopt or amend the budget. Now that makes good sense, doesn't it? Since you're the entity that's going to be receiving those state funds, you're going to have to authorize the expenditure of those funds as a board. You can't delegate that authority. Here's another one. Public records. The requirement in the law is that you must keep with the charter holder board the authority to direct the disposition and safekeeping of public records. Now, that could be a real clumsy requirement if every time you wanted to put a record from here to here, you had to have a board meeting and
That
an
can't be
agenda
what
item.
that means. Please tell me.
It is what it means, but they thought of this. And so the agency has told us that the board can delegate the function to a person, provided that the board retains the superior rights. It doesn't attempt to
So if
delegate.
they have to get at the records, they can.
Surely.
But there's someone routinely who can access them.
But this is going to require that the board actually delegate that authority. And again, that should be a statement in policy recorded with the charter or charter amendment if you haven't done it by now. Another authority that lies with the charter holder board is the authority to adopt policies. Can't, now there's a difference, of course, between policies and procedures. Policies would be the general, overriding, operating statements, the way that your school is going to be governed and run. The procedures would be the way that these policies are implemented. And you can have your superintendents and other governing boards set up your procedures, but the policy adoption has got to lie with that charter holder board. And then, of course, there is the final authority to select the chief executive officer, the superintendent, as you are, of a charter school, has to rely with the charter holder board.
But the other staff members could be delegated to that chief executive officer.
Yes.
That's correct. Okay.
Yes.
That's important to know.
Now, one more piece about delegation. The rules also tell us that with regard to that CEO has got to retain certain non-delegable duties. The organization of the charter school central administration lie with the CEO, unless, of course, the board takes that prerogative. The approval of reports or data submissions required by law.
That makes sense.
Yeah. And the selection of the school's employees or officers, unless the board overrides that decision. One more piece of information about the non-delegable duties of the board. The audit, approval of that annual audit
Yes.
that all charters
Right.
have to do, got to rely, it has to lay with the charter holder board.
Okay. Well, that's not too long a list.
No.
The whole issue of liability, as you mentioned, is really frightening to board members, and I think that it would be good to know if there's any exceptions to the immunities that you discussed.
Well, there's always exceptions. That's why we have lawyers, I suppose.
What if a board member, for example, does something that's not really a consensus item? They're not acting as a part of the board, and they take some type of action. Is the entire board liable for their?
Let's do good news, bad news again.
Okay.
The good news is even if you have constitutional claims of constitutional proportions coming in under federal claims or even state constitutional claims, the law provides, and the cases that discuss that law provide for good faith immunity as long as you are acting as a board member in good faith within the scope of your responsibilities. Now, that's a very important phrase, within the scope of your responsibilities, because if you go outside the scope of your responsibilities as a board member and attempt to act individually, you may very well lose that immunity. In other words, the safest place for you as a board member is to stay within the confines of the board.
Well, that's a good incentive for everyone to work together and be on the same page.
You have no authority otherwise. Your only authority as a board member is when you vote with your board.
Okay. Good. That keeps it simple. What do you think that board members should know about the charter? I know that our charter file gets thicker every year, and we've only been around 6 or 7 years. I don't know that I could really ask them all to commit all those pages to memory, but what's your advice about the charter document and the charter file and that board member training?
Read it. Board members should have a basic understanding of what is in their charter. I know some of the board members were involved in the setup of the charter, so they're going to be fairly familiar with it. But as we discussed earlier, what the agency has told us is they will consider all the application materials filed with the charter as the charter. So, so many times schools that have been operating for a year, 2, 6, may have changes in the operation, changes in the curriculum, changes in the officers, changes, of course, on the board, in the governing structures, changes in facilities and where they're located. All these items are there in the charter, and when those changes occur, they need to be reflected in the charter as a charter amendment.
So really the whole amendment process should be almost an ongoing review cycle. So you're continually amending your charter as you're amending your actions.
Yes, ma'am, and as I know you know, when a renewal cycle comes up for a charter school, the agency is going to be looking at every one of those issues.
And looking for inconsistencies.
That's
makes
right.
Sense. What about the worst case? Is there something that can happen on the board, some lack of accountability or fulfillment of these duties that could cause you to lose your charter? Or does a charter last forever?
No, the charter doesn't last forever. The charter has a duration that is described in the charter. I know many of the charters being issued now are granted on a 10-year basis. This doesn't mean that you're there for 10 years without review. The agency has the authority at almost any time during the life of your charter to look at your operation to see if you're consistent with the laws, to revoke the charter, to non-renew it if your renewal is up, to put you in a probationary status, and with certain exceptions, because we don't want to stop the education process, cut off the funds. So it behooves all of us to understand what those requirements are. It's the purpose of our training.
Well, what are some examples of things that could cause us to lose our charter?
Well, what the agency is looking for more than anything else is accountability. They want accountability with regard to the process that is required for reporting. Because that's how your funding is done, through the number of students that you have, through the types of students that you have, through the attendance. And if your reporting is inaccurate or perhaps non-existent in some cases, that can create great problems for your charter, and you stand the potential of losing the charter. Another area is accountability with funds, obviously with financing. So everything that has to do with the expenditure of our funds, of our state funds and federal funds that flow through the agency, is going to be something that they're going to watch very carefully.
And student performance. I'm sure there's some level at which student performance itself.
Well, that's the third element. You know, it almost seems like that ought to be first.
Right.
Because that's why we're in business. And if students aren't performing, if you have a couple of unacceptable years, you're going to be hearing from the agency.
You know, you talked a little bit earlier about some areas of board responsibility that really have more to do with how they interact with one another. For example, conflicts of interest. I think that's an area that we need to talk about further, because I think my board members are going to want to understand what triggers that so they can make sure they stay on the right side of that, as well really as nepotism. How they know when they're in that type of a relationship is going to be critical for them.
Well, what do you want to hit first? You want to hit,
Your choice, really, either one of them.
well, let's talk about nepotism first. You know, basically what it is.
Yes, you
It's
gave me a
this-
short definition.
It's this family relationship that is prohibited by the law. And what our charter laws refer to is the nepotism laws that apply to all state governments in the state of Texas. And then our charter rules expand on that a little bit, changes it slightly. What's important for us to know is that the nepotism laws apply to our charter holder board members, our charter school board members if they're different from the charter holder, and to officers of the charter school. Now, in applying this to officers of the charter school, the law is making a distinction for charters from that is applied to public schools and other governmental bodies.
I guess that means we need to know who is an officer.
I'm about to tell you. The definitions include campus principals, assistant principals, directors, assistant directors,
A lot of people.
and finance officers. And so these people can be out of sync if they are in a nepotistic relationship with folks that are on either one of these boards that we just talked about.
It makes it tough for family schools that converted to charters. Are there any exceptions to these nepotism rules?
Yeah, there's some exceptions, but first let me tell you a little more about the rules. The nepotism laws are divided into two basic categories. Now, I'm going to use some big words.
Okay, I'm prepared. I'm ready.
Consanguinity and affinity. Consanguine from the blood. A blood relationship versus a marital relationship. And we say that two individuals are in a relationship of consanguinity when they're related by a common decedent, or if they share a common ancestor, or if they have a common decedent. And for that purpose, an adopted child is considered to be a child in consanguinity. Now, affinity is a little different kind of rule. Affinity is the relationship by marriage. In other words, a relationship by affinity is the marriage of two individuals, or if someone is related by consanguinity to the other individual, that can also fit under the affinity definition. Now, this sounds like it's going to get confusing, but it really, I can straighten it out for you. First of all, let's understand that not every relationship in consanguinity and not every relationship in affinity is a nepotistic relationship. Isn't that good? Because, as I said, we're all related within 6 degrees.
Right.
And so there are degrees of affinity and consanguinity. Let me give you consanguinity. For example, in consanguinity, we have up to 3 degrees of consanguinity that separate the individual from his or her parent or child, brother or sister, grandparent or grandchild, great-grandparent, great-grandchild, an aunt who's the sister of a parent of an individual, an uncle who's the brother of a parent of an individual, a nephew or a niece who's the brother of or sister of an individual. These would be relationships within the 3rd degree of consanguinity and thus forbidden under the nepotistic laws.
That's a large group of people, though.
Yeah, it is. Now, for affinity, we told you that the relationship is by marriage. And spouses are related within that 1st degree of affinity. But for others, the degree of the relationship is the same as the degree of the underlying relationship by blood, by consanguinity. So when we're counting the number of degrees for affinity, and actually the forbidden number of affinity degrees is 2 instead of 3 for consanguinity. 2. So in other words, if you're outside of that 2, if you're in that third degree for affinity, you're all right.
Okay.
You're not in a nepotistic relationship. When you go to consanguinity, you'd have to go to that fourth step of separation
To be
before
okay,
you
to be safe.
before you were safe. So when we talk about the underlying relationship by consanguinity, let's say that my wife would be the first step in affinity. We're not blood related, but we are married. What would her brother be to me in steps of affinity?
Is it second?
Exactly. Because we count the relationships by blood from the person related in affinity to get the number of steps. Now, what about the child of my brother?
That would be third.
Okay, wouldn't it?
Yes, it would.
Okay, you
Yeah,
got it?
now I know that, yes.
Very good.
I guess I'm a little confused, though, about the consequence of all this. If you have someone who's working, let's say that you have a teacher and a principal that get married. I mean, schools can be very close communities. Does that mean one of them has to leave the school?
It depends. First of all, let me tell you what the prohibition is. A board or an official, an officer, cannot hire, select, appoint, or confirm the appointment or vote for the hiring, selection, appointment, or confirmation of any individual that's within how many degrees of consanguinity?
3.
Good. And how many degrees of affinity?
2.
Okay, that's the
I'm catching
basic
on.
rule. Basic rule. Now, there are exceptions. Good that there are exceptions. Bus drivers in certain small communities are accepted. It's because we couldn't get bus drivers.
I was wondering
otherwise.
that.
Right. Assistance for disabled persons that may be related within these forbidden degrees can be accepted because of the humanitarian need.
That makes sense.
For the purpose of charter schools, substitute teachers are not under the nepotistic standards.
And that's good.
They're
Because
accepted.
we all have trouble finding good subs.
Right. There is another exception under the nepotism law itself, and that is if the person that is on the board or the officer of the school has been in that slot, takes the slot within, I'm going to go from memory here, I believe it is 6 months of the time that the person in the nepotistic relationship was employed by the school. It is an exception. So let me state that for you again. Let us say that you worked for the school since last year. 3 weeks ago, your brother was selected to serve on the board.
So that's more than 6 months.
That's more than 6 months. Okay. And the nepotistic relationship would not exist, provided, there is a proviso here, provided that the person that is in that nepotistic relationship not take part in any decision about you,
Oh, I see.
about your salary, about your promotion, about your assignments,
So you have to watch your reporting structure.
and provided that an affidavit is filed with the school.
And that's for employees as well as officers.
Well, that would work for
as well as-
anybody that's described under nepotism for charter schools. It's the officers and the board members for both the operating board and the charter holder board. Now, there's another wonderful exception for charter schools, and that is the exception from nepotism for schools that have been academically rated as acceptable for at least 2 of the last 3 years.
How does that exception work?
Well, you still have to file your affidavit. You still have to abstain. You can't take part in the voting in the same way as the previous example. But, and it works just fine. Many of the
So
schools,
it's pretty broad.
many of the schools
broad
qualify
exception.
under that, right?
Well, that's a big help. Are there any other types of conflicts, provisions, or limitations that we need to know about? before we leave the subject?
Well, before I leave the subject, I want to make sure that we understand that these exceptions that we talked about just a moment ago have some certain nuances. If the official that has been previously hired by your school is an officer, or if that officer is the person that is making a decision about someone in a nepotistic relationship to them, the time period that must pass is 30 days, not 6 months.
Okay, could you repeat that again?
Okay. 6 months if the official is a member of a charter school board. 30 days if the official is an officer.
Within the school, that's the principals, directors.
You got it, assistant, financial officers. And the one other exception here is if the official is a member of the charter holder board as opposed to the charter school board. The time period that must be in place is a whole year.
So really, you're going to need to have this accessible so you can review it based on the exact position the person has.
You got the 30-day rule, you have the 6-month rule, and the 1-year rule. And it depends on the type of official that is in the nepotistic relationship.
Okay, I'm glad you pointed that out. I wasn't clear on that.
Okay.
You know, we've really got a thorough understanding now, I think, of conflicts of interest and also nepotism, but I know there's another area that's received a lot of recent attention, and it has to do with management companies, the types of conflicts that can exist with the utilization of management companies. Is there any clarification you can give us on that topic?
Well, I think the first thing we need to understand is what is a management company under the definitions that the agency has provided for us. And we know that there are certain activities which may be performed for a charter school which have been described as management services. If there is a company, a business, a person, providing any of these activities, the agency is inclined, in fact probably will, deem that to be a management company. So let me tell you what those activities are.
Sounds like a broad group.
Yeah, it is. And there's so many of them that I've made some handouts for you, so let me refer to them myself. If the entity or person plans, operates, supervises, or evaluates a charter school program or service or facility, it's performing management services.
It evaluates.
Mm-hmm. Or if it plans, operates, or supervises.
That's pretty much the whole range.
Huge. If it makes recommendations to the governing body of the charter school or the charter holder board regarding the selection of personnel for the school. Management services. Of course, if it manages the charter school on a day-to-day operations basis as the administrative manager, that's a no-brainer.
Sounds like a lot of consultants may be management companies.
Exactly. If it helps to prepare a proposed budget to submit to the charter holder or the charter school board, and you know you're going to be doing that on an annual basis, management services. There are other management services that are described by the agency. For example, the preparation of policies for the charter holder board or the charter school board, management services.
Does that make your attorney who helps your policy drafting?
There are a couple exceptions.
Just checking.
We made sure that the lawyers are not included and the CPAs are not included. And I say we, the agency, made sure that would not happen. If the development of procedures under those policies, remember we distinguished between procedures or policies?
We did.
Well, even the development of procedures under policies for the charter school, management services. If the entity or person oversees the implementation of the policies, management services. And lastly, there's probably a lot of contracts out there where there are services that provide leadership for PEIMS performance, Chapter 39 performance on meeting the accountability standards, management services.
That's very broad. It sounds like it could be quite a trap for boards that aren't familiar with that definition.
It is, and
When does it matter, though? What are the real consequences?
well, it matters every time you enter into a management contract.
No, but what are the consequences in terms of conflicts?
Well, the contract is void. If the agency's got to approve this contract, Rosemary, and so you have an obligation to submit the contract to the agency 30 days prior to the time the contract would become effective. And a failure to submit a contract makes the contract void. The agency wants to review the management contracts.
So it's really not just board members, but it's also vendors and consultants that need to be familiar with these laws.
Well, hopefully they are, but yes.
Because they wouldn't want their contracts to become void.
Yes. Now, there's a couple exceptions that we should know about. We talked about what a 501c3 was. And a 501c3, remember these are these
I do.
IRS entities?
I remember that.
They can donate management services to a charter holder under certain circumstances. If the charter holder is a subsidiary corporation of the 501c3 donating the services, and there's a close control between the boards of both those corporations under the Articles of Incorporation or the bylaws, that is not deemed to be management services.
Now, if there's donated services, but there's not a close relationship between the 501c3?
You have to have both.
Okay, that's interesting.
Yes. Also, the services of a regional education service center, not management services.
That makes sense.
As we said previously, neither the services of your attorneys or your auditors.
Okay. Anything that we need to know that we haven't covered on management companies? Because
Well, there's probably a lot that you need to know on management companies, but I would say there's more than what we could cover in this presentation. So.
Well, I know one thing we haven't really talked about is students, but before we go there, I have a particular situation at my school that I wanted to run by you, because we haven't really hit on any laws that would impact this, but I have a feeling they're out there. As a part of our growth process, and I'm sure all the schools that are growing are encountering the same situation, we ran out of space, basically. And so we had to add some employees, some professionals, some a business manager, as well as some consultants to perform auditing services and architectural services for our school as a part of our growth plan. And we actually had to purchase property because we received a foundation grant that allowed us to expand our building. Are there any laws that have come into effect in the last few years that might impact how we go forward?
Yeah, well, your description suggests a whole lot of laws. Let me give you a basic piece of information about charter school and procurement, purchasing for charter schools. Charter schools are, although they're required to spend the state monies that they receive and the federal monies, only for the purposes that a public school could spend, school district could spend the monies. Charter schools are not required to follow a statutory process for the procurement, for the purchase of supplies and goods, as opposed to school districts, which are. But there's a lot of other statutory requirements for the procurement of other types of services that charter schools must follow. You talked about some construction work that needs to be done. Charter schools have been, by law, referred to a section of the local government code that requires process for bidding these services. What many schools have done is taken advantage of another section of the law which allows them to apply for a charter amendment that then applies to that school a different set of procurement laws that public school districts use when they're building and constructing. The advantage of that is that there's a much wider range of possibilities for the type of contracts that can be entered and the processes that are used to make a determination of who will be your builder. And
is it difficult to get that kind of amendment if you want to choose that route?
Well, you have to apply for your amendments within the period of time that the agency will allow you to. But but no, it is not. The agency has been very gracious in granting those amendments. They want to see the charter schools have as much flexibility as possible. So that set of laws is impacted. You talked about hiring auditors. You talked about hiring architects. Well, by law, there's a requirement for charter schools to use a certain process in the hiring of these professionals. And it's called Professional Procurement Act. In Chapter 12 of the Texas Education Code, down under this stack of papers, Chapter 12 tells us that in order to hire architects, in order to hire engineers, accountants, surveyors, doctors and nurses, even real estate appraisers, all classified as professional services, we must go through a special process called a two-step process. I'll just tell you briefly. The process requires first to determine which of these architects, engineers, accountants are best qualified to perform the particular job you have in mind. You, the charter school, has in mind.
Without any discussion of price.
Exactly. No discussion of price whatsoever, just merely qualifications. Rank them. Decide who's the best, second best, and third best. Once you make that decision, then you can enter into negotiations and discussions regarding price and other aspects of the contract. And if you're unable to reach a contract with the first on the list, notices can be sent out and you go to number 2, number 3, and so forth.
Now, is there a threshold? If you're hiring an architect and they're going to do, this is hard to imagine, but let's say they're only going to do $5,000 worth of services. Do you still have to go through this process?
You do.
It's good to know.
Important, because the law says if you enter into a contract that doesn't follow the Professional Procurement Act, the contract is void.
Well, I'm sure they wouldn't be happy about that either.
Well, the architect's not going to be happy.
What about the fact that we're using grant money for part of it? Does that get us out from under some of this?
No, not at all. In fact, what happens when you're using grant money is that in fact, all the time, the grants will have certain conditions and requirements for processes that you're required to use. And you always want to read your grants very carefully and not just depend on what's in your state law, because many of these grants are federal grants, not just depend on what's in the state law for determining how you're going to make these procurements and purchases.
Well, you know, mixing private and public money raises the issue that I have also heard about recently that falls under the category of tracking. Are there any cautions you can give us about when we need to track what we've purchased with public versus private funds?
All the time. You need the services of a good CPA and good auditor, someone familiar with charter schools, because there are special requirements for annual reporting, keeping track of how these funds are spent by the charter schools and determining how much of the state monies have been invested in the charter school facilities, goods, and the state actually, depending on the formula that is applied by the auditors and CPAs, books on the books an interest in that the charter school assets. And at the end of the existence of the charter school, there will be an accounting.
Well, I'm glad we're learning that now before we get into the process. I think once we have room for a new business manager and an attendance person and someone to handle PEIMS, we're going to be in a lot better shape with our school. But today we've really focused so much on the board that I'd like to have you talk just a little bit about some of the issues that our board needs to be aware of with regard to students, enrollment, admissions.
I'd be happy to, but you know, I'd be remiss if I didn't tell you a few more things about the purchasing requirements. Charter schools have an obligation to follow certain other laws when dealing with purchasing. For example, when you're selecting a depository bank, there's a requirement that the charter schools contract with their depository banking institutions, and that banking institution has to be one that's defined by a certain section of the law. For your information, it's the Education Code section 45201. These are certain types of federally regulated banks.
So it's a protection really for the charters.
Exactly. Exactly. And of course, charter schools are also are going to be held responsible for accounting for their the expenditures of funds, and the way those funds are deposited and used through a special set of rules. It's called the Financial Accountability Resource Guide, not just for charters. It's for school districts across the state, and charter schools are brought under that by the law.
I've seen that guide. There's an awfully lot of data. There's so much data in that you almost have to have a special employee just to be familiar with it.
Yes, well, certainly you need a qualified auditor and CPA.
Anything else before we talk about students?
No. I think we've talked about the construction methods and the professional service contracts, so I think we're ready to talk about students. Let's see. What do you want to know about students?
Well, I'd like to start at the beginning and talk about enrollment and admissions first. It seems to me there's been a lot of recent questions about what is and isn't permissible on the admissions side, and I know the charter also has some enrollment criteria that govern that process.
Okay. We're called open enrollment charter schools for a reason. That is that within the geographic area or other areas that are described in your charter, you are required to enroll all applying students. And you can't make exceptions because a student may be of a certain national origin, ethnicity, religion, disability, or because their academic standards aren't as high as you'd like, or because you're attempting to run a magnet-type school like an artistic center, or you want to make sure students of certain athletic ability attend your school and not others. These are discriminatory admission standards, and of course they include such things as sex too. Can't have an all-boys school and all-girls, you know.
But you can limit for space. You mentioned taking all students. Actually, charters are able to limit on...
What happens is that your charter will specify a maximum number of students, and within that cap, that number, you'll be taking on students as they apply.
Okay.
Of course, you know that most charters use the lottery system for selecting the students that will be permitted to attend once that cap has been reached. There's a reason for that. Both the state and federal laws require it.
Tell me a little bit about the lottery.
Well, the lottery is, according to state law, the lottery doesn't come into play, or doesn't have to come into play, you can use it at any time, until the cap is reached. What many schools do, however, is use the lottery from the very beginning, even though the cap hasn't been reached. And of course, all names go into a pot. You make a draw, and there is an opening and closing date for the applications as required by law. The application notice has to go into a newspaper of general circulation, and the lottery cannot be held sooner than 7 days from the date of that notice, according to the law.
Well, it sounds like an egalitarian process, but one where you're going to have to keep your record so that if it's ever questioned, you have documentation.
Definitely. And of course, I'm sure you are aware that the applications that are filled out by the students are many times reviewed by the Texas Education Agency, both in the initial charter process and in the renewals, and sometimes in audits, to make sure that the applications don't have questions that would suggest them to be discriminatory.
That makes sense. I know there's other areas that probably overlap on admissions and enrollment, but in general, one of the things that the boards continually want to know about, particularly since they didn't come from public education, is curriculum requirements and graduation requirements. Any comments on that?
Yeah, I can tell you a little bit about them. Before I leave enrollment, I want to give you one exception.
Good.
If you're a charter school and your charter states that you may decline to admit a student that has a documented history of criminal offense or juvenile court adjudications, or even discipline problems under the public school discipline standards, if your charter says that you can decline enrollment to those students meeting that definition, you can.
And if your charter is silent?
And you want to decline admission, you better have a charter amendment.
You better amend your charter,
right?
okay. That makes sense.
All right, now, what was your question again?
Well, I'm just really kind of wanting to know about curriculum and graduation requirements. Once the students are in your school, what are some of the laws that impact their
Well, you've just named them.
intellectual life?
Yeah, you're going to have, your charter school is not exempt from curriculum requirements. It's the same as a public school district. And graduation requirements are also in place for charter schools. In fact, there's been a recent adoption of a piece of legislation that is going to require charter schools like the public school now, public school districts, to provide assistance to graduating students that are having difficulty and are at risk. So there's a program requirement that is in place for charter schools at this time.
So the minimum graduation requirements are the same, but of course charters like districts can add to that minimum.
Oh yes, certainly. And some of them have very, very high standards.
The teachers that actually are responsible for that curriculum, there's an area that I know really it's in the process of changing, but is there anything that you would like to share today about teacher qualifications?
Yeah, I wish I knew all the answers to the teacher qualification.
The new ones? We do
Yes.
too.
It's been it's on the mind of not just the charter schools, but it's in the headlines of schools across the nation. And the headlines have been produced as a result of the federal laws under No Child Left Behind, requiring all schools, including charter schools, to hire highly qualified teachers. And what we know is that in certain core subjects for this year, core subjects such as math, science, reading, and there's some others you're probably more familiar with than I, the highly qualified standards are in effect today. Now, for charter schools, what the law has said is that the certification requirements for charter schools can be the same as that adopted by the state. Well, we know that for charter schools, or maybe you weren't aware, but for charter schools, the certification to teach is, and the qualifications to teach is a high school diploma. And not a college degree, and certainly not a teaching certificate, as we know, for the public schools. However, in these core subjects, we are going to be required to do one of two things. We either provide a certified teacher, which, under No Child Left Behind, meets the definition of highly qualified, or we provide teachers that have passed certain state examinations in these subjects. The surprising news, perhaps, is that these examinations have not been developed and promulgated as of this point. So there's a question in the air right now, but it looks like at this point for the core subjects that we're going to need to provide the certified teachers.
Well, it sounds like we're going to need to read the headlines of the newspaper and talk to the TEA.
We have to watch this very carefully.
Often. I know that we have a lot we could discuss regarding No Child Left Behind, but since so much of it isn't resolved yet, if we could finish this particular session by just a few comments on the whole area of tuition and fees. I think that's another place where there's some amount of misunderstanding. I know in our school, often families get through the lottery, show up the first day, and then inquire about their tuition bill, even though we've explained over and over again there is no tuition.
Well, you said it. There is no tuition.
But I understand there's some fees that you can charge.
Well, the same fees that can be charged in the public school districts can be charged for the charter schools. There's a whole list of them, but basically they deal with take-home projects and voluntary membership in clubs and PE clothes, security deposits. Schools can require uniforms provided that they go through the same kind of uniform policies that are applicable to the public school districts. Extracurricular activities, parking IDs, volunteer off-campus credit courses, charge a fee for. And summer school, but not if they are graduation required courses offered in a regular year.
Well, that makes sense. So, but there is still no potential for tuition in a charter school, is that correct?
Well, actually, for most schools, that is correct. There is the potential of a tuition requirement for certain schools with underage children, pre-kindergarten.
Okay. Thank you so much for all your help today, Bob. I think it's a lot of topics have become clear for our board and hopefully for other boards that watch this tape.
I hope so. Thanks.